Yeah, ladies and gentlemen, Representative Chairman Jackson brings us HB 425 dealing with abortion. It's a constitutional amendment that stipulates that no provision of the Constitution protects a right to abortion or requests the funding for or requires the funding for abortion. I should have put my glasses on. Representative Jackson, on your bill.
Thank you, Mr. Chairman. Actually, it is a conglomerate bill. It's not Representative Jackson's bill. I believe it's the people's bill. The two people most responsible for this piece of legislation and researching are sitting behind me, which is odd because they're usually sitting beside me, but we have the governor's office who wants to speak and has some other bills to speak on, and then we're going to switch out. But this bill will finally give the people of Louisiana an opportunity to vote on an issue that we voted on numerous times, and that's to say that we are against the shedding of innocent blood in Louisiana, that we believe in life and that we support life. I am a pro-life advocate who supports life. I like to tell people from the womb to the tomb, right? Not only to give opportunities for mothers to choose life from the date of conception, but to also provide much needed resources to the mother and the child after they choose life. So it brings me great pleasure to present this to the Civil Law Committee. I think I'll be before another committee and then before the House, and we're looking for co-authors so that the people of Louisiana can prove what everyone else has said about our state, is that we're the #1 pro-life state in the nation, and that we care for life at every stage of life. And that's basically what myself, Right to Life, who's going to come up and speak, Dorinda Borley has been talking about, and Governor Edwards and his staff, and this young lady who's helped as well. It is very important that at some point we put this in place, and that time is now. There was another state, which they're going to talk about because they do more research than me, where their Supreme Court just recognized a right to abortion in their Constitution. And it seems to be the new movement to go state by state and determine whether or not each state constitution recognizes a right to abortion. This would put us at the forefront before a suit is ever filed, that we would be clear, our people would have an opportunity to vote on it, all of your constituency, that we do not recognize a right to abortion in the state of Louisiana in our Constitution. And I'm going to turn it over to Matthew Block, who probably has a number of committees to go to besides this one.
Welcome to the Committee on Civil Law and Procedure, Mr. Block. We appreciate you coming to testify today. Did you fill out a card?
I sure did.
Okay. We get the Sergeant at Arms to pick that up for us.
Yes. Thank you.
Very good. Please proceed.
Thank you for having me. I appreciate being here. Matthew Block with the Governor's Office, and I'm happy to be here on behalf of the Governor to support this bill. This is a bill that we have worked with Representative Jackson, with Louisiana Right to Life, to support this bill. And I think what Representative Jackson said clearly about what this bill does is exactly the reason we support it, in that we want to make it clear that the Louisiana Constitution does not provide for a right to abortion. That's what this bill does, and that's what it does clearly. And we think that is something that, as Representative Jackson said, that the Louisiana voters should have a right to have their voices heard on this. Obviously the governor is strongly pro-life and has made that clear in his entire public life. He supports this legislation, and we ask you to do so as well. And I'm happy to answer any questions that you have.
And I think you stated it, but as I read the bill, it doesn't require anyone to do anything.
It does not.
It's just merely stating that if you challenge the Constitution for whatever reason, that we're not going to interpret it as supporting abortion.
That's it. It's just limited to interpretation of the Louisiana Constitution.
Excellent. Okay. And who else is at the table with you?
Good morning, Mr. Chair, Mr. Vice Chair, and members of the committee. My name is Dr. Kathy Allen. I'm State Director of Black Advocates for Life. I'm also the proud mother of a 12-year-old son who has Down syndrome.
Pardon me, Dr. Allen. Did you fill out a card for us?
Yes, sir.
Okay. I don't seem to have it. I'll look through here, but please proceed. I apologize.
I'm the proud mother of a 12-year-old son who has Down syndrome, and I'm one of thousands of women around our state who unfortunately have personal experience with abortion. My support for this proposed addition to our state constitution is based on two factors. First, the Love Life Amendment provides critical protection for current pro-life legislation. And second, the proposed amendment potentially has the effect of changing abortion discourse from a discussion of civil rights to a discussion about community-based resource and support systems. The Love Life Amendment provides a significant layer of protection for current pro-life laws and regulations which protect mothers and save babies. I know from personal experience and from conversations with women and men around the state that the decision to have an abortion is usually made in haste and in fear. There are many scenarios that lead to abortion, but one unavoidable, commonly occurring outcome is regret. It may be immediate, or for some of us it may take many years, but at some point, every person who has been involved with abortion in any way, having an abortion or paying for one, encouraging one, or performing one, realizes that abortion ends the life of a human person. The shame and guilt that results from regret often produces a posture of silence that prevents reaching out to others and saving lives. In addition to this, I have the privilege of being the mother to Joshua Lewis Allen, my gifted, insightful, and joy-filled son. Joshua is 12 years old and happens to have Down syndrome, which is the best syndrome, by the way. Mm-hmm. Over 70% of mothers who have a prenatal diagnosis of Down syndrome choose to abort these wonderful children, boys and girls who have talents, intelligence, and something to contribute to their communities. Our current laws that require ultrasounds, waiting periods before obtaining an abortion, and parental consent for underage young women are frontline offensive weapons that save the lives of unborn babies like Joshua and other babies who will be future classmates, friends, colleagues, and community leaders. These laws give desperate women the opportunity to think and to consider whether there are better options than abortion. Countless women have stated that the opportunity to see an ultrasound image of their womb helped them to realize that they were carrying a life and that the life within them deserved to have life outside of the womb. The Love Life Amendment ensures that the pro-life laws that protect mothers and unborn babies, the laws that protect the future of our communities, remain intact and available as measures to reduce fear, promote thoughtful evaluation of options, and ultimately save lives. Further, the Love Life Amendment places the discussion about choice in the communities that hold the solutions to the problem of abortion. Many abortion defenders talk about a woman's right to choose. We certainly all have a right to choose to do with what we wish with our bodies, but all rights must have parameters. They must have boundaries. Many of us who have experience with abortion felt at one time that we had the right to determine whether we wanted to be a parent, whether we wanted to interrupt school or work, or whether we wanted to injure our reputations. We realized the hard way that wanting to do something on our own timetable does not eliminate the responsibility to protect the lives that are connected to ours. I do not have a right to do something with my body that will bring harm or death to another human being. The Love Life Amendment, rather than suggesting that abortion is a civil right, would promote a more robust discussion about choice in individual communities. Ideally, we want to talk about the right to choose in the context of socially just policies that promote life-affirming choices. A community that is focused on creating support networks and identifying sustainable resources for mothers, babies, and families can more effectively promote life-affirming choices that improve the well-being of the community rather than the choices that destroy the future. The Love Life Amendment is a critical piece of our future that supports all life in every stage and in every condition. I ask you, as a woman who knows the pain of abortion, as a mom who sees the value in a child who many women might have aborted, and as a member of a community that I want to see choose life in every way, to please support HB 425, the Love Life Amendment to the Constitution of the State of Louisiana. Thank you so much.
Thank you, Dr. Allen. We appreciate you coming to testify today. Anything else to add while you're still at the table before I bring some other people up?
Sure. I'm not sure who's authoring that amendment, an amendment to change the date of the election, that this amendment would have put on a ballot. I think that's Representative Seabee, I'm sorry, on that first amendment.
I believe it is as well. You ready to offer that amendment, Representative Seabee?
I haven't actually seen it drafted yet, but I requested
Get it passed out?
that we change it from the November runoff date to the October primary date.
I believe it's coming out now. Okay, members, you will receive Amendment Set 1125, offered by Representative Seabee to Representative Jackson's bill, which essentially, if I understand it correctly, just moves it up to the primary date as opposed to the general election date, correct?
And the reason for that was felt it's going to be a larger turnout. The primary is always a larger turnout than the runoff, and it's broader appeal across the state. Some areas there might not be runoffs, so I thought we'd get a better shot at it in October. And I visited with Katrina about it yesterday, or excuse me, Representative Jackson about it yesterday, and she agreed.
Okay, members, any objections to the adoption of the amendment? Seeing none, the amendment will be adopted. Back on the bill, Representative Jackson.
And members, I was accepting of this amendment. I talked to Ben and Dorinda, who really have helped and shaped this bill. And I believe that I'm going to be calling on all of you at some point to help promote it, because that gives them, that cuts off a month of advertising and making sure that our constituency know that it's on the ballot. It will then be on the ballot with a number of other amendments. So you'll receive an email from me at some point asking for your help in communicating this early on while you're here to your constituency, to make sure that it's not muffled in 5 or 10 other amendments that may be on the ballot because of the importance of this one. So I'm going to be looking for you guys to co-author and help us as well along the way.
Very good. You ready to go, Mr. Clapper?
Sure. Chairman, members, thank you. Ben Clapper, Director of Louisiana Right to Life, state's pro-life organization, been in existence since 1970, certainly, as you can imagine, before I was there. So thank you for your time today. We're supportive of this bill, this constitutional amendment, HB 425, the Love Life Amendment. We recently did a poll of the state and found that 70% of Louisianians self-identify as pro-life. So this is a good starting place for this amendment to put before the people to support this pro-life principle that the right to abortion should not be found in our state's constitution. My colleague Dorinda Borley is going to talk a little bit more about the details, but members, I've distributed, or the Sergeant Arms distributed some of our petitions that you've received. We've collected in 2 weeks' time since Representative Jackson filed this bill, currently 5,438 petition signatures supporting this constitutional amendment across the state. This stack and this box are actually petitions that have been unappended with Senate and House districts, so many of these could be your constituents, but they just come in the past few days, so we haven't had a chance to put the House and Senate districts on it. And then the boxes down to my right are the other petitions for other members that we'll be distributing this week and then next week when the bill is considered. So the state's supportive of this. We believe this is a pretty modest measure just to ensure that the decision on this issue remains with the people and their elected legislators, not with judges in our state courts. We thank you so much for your support, and we look forward to the passage of this amendment. Thank you.
And just for clarification, the petitions are read because it's the...
Yeah, so this amendment isn't... Thank you, Representative Garofalo. And your wisdom told me that this should be a green set printed amendments, petitions, so they don't look like they come in opposition. But the theme of this amendment is the Love Life Amendment, red, hearts, all that good stuff. So, but we'll have to think about green next time. From now on, you'll be my color
well,
advisor.
I don't know if I'd be very good at that. At least according to my wife, I wouldn't be. But that's... Mr. Bordley, would you like to say a few things to that?
We have another amendment as well.
Oh, do we?
I'm not sure who will offer that. Yes. It is to add language to the bill that says to protect human life, nothing. That's literally the language.
Not prepared.
Yes, they have it. They're going to pass it out.
Okay, members, you're being passed out Amendment Set 1123. And can we get staff to describe this to us?
Members, this is Amendment Set 1123 that's being handed out right now. It is changing the language on page 1 at the beginning of line 11 so that it will read, to protect human life, nothing in this Constitution shall be construed to secure or protect a right to abortion or require the funding of abortion. And then Amendment number 2 is deleting the current ballot language found on page 2, lines 1 through 4, and replacing it with the language that is on the amendment that you just handed out, which reads, do you support an amendment declaring that to protect human life, a right to abortion, and the funding of abortion shall not be found in the Louisiana Constitution.
Okay.
Thank you, Mr. Singletary. Representative Jenkins, you have a question on the amendment?
Yes, Mr. Chairman. Thank you. You know, one of the concerns I had about the amendment, first of all, let me say I understand and don't have any problem with the people voting on the issue, okay? Yes. But one of the concerns I had was that I didn't see anything in here that dealt with the commonly accepted exceptions, rape, incest, life of the mother. Does this cover that? Does this amendment encompass those exceptions? That was one of the things I had some concern about.
Could I answer that question, Representative
Anybody
Jenkins?
at the table can answer that.
Hi, my name is Dorinda Boardley. Mr. Chairman, thank you for allowing me to be here. I'm here for information purposes only as an attorney to explain the bill, what it accomplishes, and these kinds of questions. I'm with Bioethics Defense Fund based in the New Orleans area, but we work on a national level. The quick answer to your question is that this amendment would, the whole effect of it is to leave the abortion issue entirely in the hands of the people through their elected officials, that's you, rather than in the hands of state court judges, because in 12 states, the state Supreme Courts have interpreted their state constitutions to discover a right to abortion where there is no text to that effect. They take the privacy clause of the Due Process Amendment and they interpret it to say there's a state right to abortion, and they use that to strike down common sense laws like ultrasound laws and women's right to know laws. And if Roe is ever reversed and sent back to the states, instead of the people deciding in the legislative process or the democratic process, the state court has already decided for them. And that, of course, is a usurpation of the legislative process. So to answer your question, in 2006, this body passed a law that says if Roe versus Wade is reversed and the abortion issue is sent back to the states, then abortion shall be prohibited in Louisiana. It addresses issues of rape and incest. Under the rape issue, it says that it will follow whatever the Medicaid requirements are. So, for example, the federal Medicaid requirements are that rape and incest must be allowed for us to receive Medicaid funding. So it will track that. But all of those details will be decided by you as the elected officials representing the people. This legislation here says nothing about rape, incest, ultrasounds, anything like that, because it's simply saying this issue of abortion in all of its measures shall stay in the hands of the people through you guys as the elected officials. So if there's something you wanted to change in the future, you could introduce a bill and run that through the legislative process instead of having state court judges usurp the legislative process like the U.S. Supreme Court has done in the Roe versus Wade decision. And that's why if the Roe versus Wade decision is reversed, a lot of people don't realize, even us as lawyers, we're so entrenched in an atmosphere of judicial activism where the U.S. Supreme Court, 9 individuals, unelected, have taken over the most important social issues of our day out of the hands of the people in the states. When Roe versus Wade was passed, the laws of 48 states banning abortion were struck down. And so when Roe is reversed, that won't mean that abortion is illegal. It means that it will go back into the constitutional structure where the people set the law through their legislative representatives, the executive executes the law, and judiciary interprets the law. So this gives the judiciary something to interpret very clearly, where they can't find, through some provision or another, a right to abortion. That's a long answer to your question. If it's confusing, I'm glad to clarify.
And I didn't want to be confusing with it. I was talking about this particular amendment, not the constitutional amendment that ultimately would go to the people.
Okay, I understand.
I was trying to determine whether or not, and I guess one of the concerns I had about the bill was whether or not it recognizes the commonly accepted exceptions. We're going to make someone go through with a pregnancy if they've been raped a victim of incest, or if the health of the mother is at risk here. That's what I'm asking. Does this language that you
to
just
protect human life is what you're asking about. By adding these 4 words, to protect human life, does that have any legal effect? Is what you're saying. And the answer is no. It's simply a principle that indicates that the principle that Louisiana respects human life, but you, of course, as the legislature, can determine, just like you do with murder laws and rape laws, and what are the exceptions, what are the defenses, all of that stays. So this addition of adding to protect human life is simply to indicate in the plain language to the voters that this is a pro-life amendment aimed at saying we're not going to have abortion. We found that when we asked, regular people on the street, when you read this legalese, nothing in this Constitution shall be construed to secure or protect a right to abortion. Okay, well, you see the word nothing and you see the word abortion, and it's not clear, is this a pro-life amendment or is this a pro-abortion amendment? So we wanted to engage that principle to protect human life. You're not going to find abortion in this Constitution, but it leaves all those issues in your hands.
The answer is no. It does
the answer
not.
Is no.
It doesn't bring in those commonly accepted exceptions. Okay, that's what I was trying to find out.
Thank you.
Thank you, Mr. Chairman.
Representative Seabee for a question.
Thank you. I want to thank y'all for bringing the bill in. I like the amendment to the constitutional language, adding the to protect human life. The issue I have is with the ballot language change. The original ballot language, to the constitutional amendment itself, you added the to protect human life, but you completely rewrote the ballot language. The original one actually literally verbatim tracks the amendment to the Constitution. The new one that's in the amendment does not. Now, it kind of says the same thing, but I guess I'm asking why the change, and especially in light of the fact that within the last few years we've had a duly passed constitutional amendment invalidated by the court because the ballot language did not, in their opinion, fairly and accurately reflect the change to the Constitution itself. So the first one more closely tracks the actual language being added to the Constitution than the new ballot language in the amendment. And I want to ask 2 questions. One is why, and secondly, why play with fire?
Okay, may I?
Yes.
Okay, so to your first question, the answer is we wanted to use plain language, and we studied the constitutional amendments that were on the ballot last election cycle, like the jury trial and so forth. And the jury trial language in the amendment looked nothing like the plain language question on the ballot. But that's the point, is that the plain language question on the ballot needs to be plain language. And so if we put too much of the legalese in there, we found in talking to people that it got confusing. So now I do take your point that we want to make sure that there's no court challenge and that it's consistent. So if you wouldn't mind, perhaps we could follow up. If we could put this on now, we could follow up and I can talk with some more of my colleagues and with you. And if we need to tweak that, we could do so on the House floor.
Okay, and that's fine. One of the jobs this committee has, constitutional amendments that come out of other committees come here for us to approve the ballot language.
Right.
I guess in this particular situation, we're doing both at the same time. It's just, and again, I can read it. I know what it says. I actually like the original one better. But
that's because you're a lawyer.
That's what I was going to say. I actually, maybe it makes more sense to me.
I like the first one better also, but when Ben and his team vetted it, people don't get double negatives in the real world. Only us lawyers do. So I think that this language accurately reflects what it is. It's neutral enough to where you're not influencing somebody one way or the other, and it indicates right up front this is to protect human life, and it's not about finding abortion in the state constitution. So
okay, and again, from a purely technical standpoint, the original language had, do you support an amendment to add a provision to the Louisiana Constitution? In the new ballot language, it doesn't say you're adding a provision. It says you are declaring that it's not there.
Representative Seabee, if we could, I think a couple other members have expressed this concern. Can we not offer this amendment and work on it, the ballot language from now to the floor?
That's fine.
Well,
I'll
or from
do
now
it either
to
way.
I'll do it to help the welfare, or from now to the floor. I'll work with you on it.
Yeah, if y'all want to put the
Okay.
amendment on, that's fine. As long as we're gonna, I don't care. We can go either way. I would like to continue having the conversation. I'll do it today, however y'all want. That's fine.
Thank you.
I do want to continue the conversation because we don't want to mess it up.
Okay, we can put it on, and then I'll work with you from now to health and
That's
welfare,
fine.
and now to the floor as well.
That's fine. If the amendment hadn't already been offered, I'll offer it, even though I got an issue with it. But
Thank you.
I do
And we
want.
appreciate your feedback. That's important.
Pardon me. Okay, we're just discussing whether or not it would have to come back to us if we don't decide on ballot language today.
If you change the ballot language, I think it would have to come back. to us.
Well, according to staff,
That's not correct.
It won't, because we've already heard the bill. It was originally referred to us. It only has
Okay.
to come back to us if it's not originally referred to
So
us.
we can work. We can always amend it on the floor if we have to.
Sure, and
Do you want to change the word declaring to stating? Was that your?
I'm just thinking on the fly. I'm just looking at what is the difference. We are, in fact, adding a provision. So the original ballot language says, do you support an amendment to add a provision? The new one says, do you support an amendment declaring that? So the question is, are we adding a provision? Or are we declaring something that was already there? You could argue that either is correct. I just want to make sure that if there is a future court challenge, that we do it right, so that we don't go through all this, pass it,
Sure.
and then have
Absolutely.
it invalidated.
No.
Right. And so if you want to offer the amendment, and then we'll work on it with you throughout the process.
That's fine.
And
I'll
I
offer
keep
the
my
amendment.
commitment, so we'll just work on it from here throughout the process.
Okay, you're
Yeah.
going to go ahead and offer that up?
I will offer the amendment.
Okay, members. Well, we have another question. Representative Dubas.
Thank you, Chairman. I am pro-life, but to Representative Jenkins' question, I'm still not comfortable with that either. I believe that there should be exceptions. So what I heard you say is that we would then, as lawmakers, have to come back and do another law. I mean, why?
So
can't we?
in Louisiana, in the Constitution, the Constitution sets forth principles, and the laws that you pass in the revised statutes set forth all of the parameters. And so we don't want to be legislating all of the exceptions in the Constitution. Right. So this simply says, however y'all handle abortion, you're not going to find a right to abortion in the Louisiana Constitution. That means it stays with you.
Yeah, let me say this to answer everyone's question on the exceptions. Roe versus Wade, unfortunately for us, is still the law. So does this change any issue with right now on a national level or even in a state regarding abortion? No. What it basically says is you will not find ever in our Louisiana Constitution a right to abortion. So when you're talking about the exceptions are still in place.
That's right.
Because we cannot prime federal law. Can't usurp it. And right now, the Supreme Court decision still stands. So you can't overturn that, nor can you overturn the exceptions.
That's a very good point, and I want to just maybe close with this. This legislation, this proposed constitutional amendment does not at all change one thing about how abortion is practiced in the state. Even after it passes, it would not change anything. It would apply in two different cases. Number one, if and when Roe versus Wade is reversed and it comes back to the state, then it'll stay with the people, not the courts. Number two, though, we see that the abortion industry is increasingly challenging common sense laws in state court rather than in federal court. And that's how they got the 12 state Supreme Courts to strike down informed consent for abortion laws and ultrasound laws and 72-hour waiting period laws. And so this will serve to protect Louisiana's pro-life laws that are on the books now from a state court challenge. And then if Roe versus Wade is reversed. But this does not directly challenge Roe. It doesn't change one thing about abortion law. Now or in the future, again, it keeps it in your hands.
Thank you.
Okay, Representative Dubas. Thank you. So just to get back to my original question, we're still not requiring anyone to do anything. Even with the amendment to the constitutional amendment, we're still just saying that we're not going to interpret anything. We're just adding the words to protect life.
That's right. It's just a principle.
Okay.
And I've always been very forthcoming to the committees. Every committee I sit before, and I'm going to be forthcoming today because I want to answer Representative Dubas and question Dubas accurately. Now, if this is overturned, Louisiana will not recognize anything. I've never sat before a committee and lied or I've been misleading. If Roe versus Wade is overturned, our Louisiana Constitution would not allow for any laws to be implemented regarding abortion. Okay? And I've always been upfront, and I thought about the statement I made. But I know there's a time that I'm advocating all over the nation for Roe versus Wade to be overturned. So with that, if it is, this provision would not allow for any laws to be passed in Louisiana regarding abortion. But the federal laws would have to be changed and not recognize any rights or exceptions. As long as the federal law recognizes exceptions to the abortion laws, then they will still be recognized in Louisiana. If it ever came to a point where the federal laws no longer recognized exceptions, then our state would not recognize them. But I didn't want to be disingenuous with my answer. I'm always trying to make sure I'm covering every basis so a member won't say later, you told me this, because 4 years down the line we may be still serving together and the federal government may not recognize exceptions. So if the federal government doesn't recognize exceptions, well, the federal laws, then we wouldn't recognize exceptions. But I can tell you this, I don't think it'll ever be in a time in Louisiana, because our legislature is overwhelmingly pro-life, that we would recognize anything or any right to abortion that the federal laws did not recognize. We never have.
But at that point, though, it would be up to us as a body to come back and add the exceptions if it were overturned, and it would be then in. Are you saying?
Right. Look, if it's ever overturned, it's going to be up to us as a body to determine whether or not we allow abortions in this state. I would venture to say, unless there's a major shift in Louisiana politics and what we've seen over the course of time, I would venture to say that will never happen in the state of Louisiana. We've been running pro-life legislation since I've been here for the last 7 or 8 years, and I staffed before that 8 or 9 years, and I've never seen a pro-abortion, even when this House was majority Democrat, pass this body, pro-abortion bill. And so we've been continuing.
I'm not suggesting we do. I'm just saying the exceptions are important to me, because I think that.
And they're federal exceptions.
Nothing is that black and white.
Yeah, and I understand, but they're federal exceptions. But I want not to be disingenuous with my answer. If it ever comes to a point where the federal government federal laws no longer recognize exceptions, then Louisiana wouldn't either. At this point, we don't recognize them. There's nothing in our law that recognizes them, and that's why it's very important that I state that there's never been anything in Louisiana law that recognizes exceptions. And I would venture to say, unless there's a major shift in the legislature, you're not going to find a majority of legislators that will pass anything that recognizes them. But it's the future legislators' rights if they so choose. So I want to be real clear, because I don't want you to come back 4 years from there and say Representative Jackson was disingenuous with an answer. Tanner knows, he sits on a committee with me, that we are always very clear on what we're doing. And with you being, a new member with a lot of wealth of knowledge, seems like, in this area, then yes, it would be up to Louisiana. I believe at this point, this constitutional amendment will stand on its face if passed by the constituency.
Thank you.
Mm-hmm.
And just to be crystal clear, the constitutional amendment that we have in front of us and the amendment to the constitutional amendment will not change any of that.
Correct. Right.
So
that's correct.
if we want to recognize exceptions in Louisiana, we'll have to do that through a separate piece of legislation.
Right. That's correct.
Okay. Representative Jenkins, another question on the amendment to the amendment?
Well, it's relevant. What is the status of Roe versus Wade now? Is the court looking at Roe versus Wade?
Every decision that comes before the Supreme Court on abortion is an opportunity for them to review Roe versus Wade. Roe versus Wade itself is not up for the Supreme Court. There's not a case that's challenging it, but there are a number of cases. Even the bill we passed in 2014, which was my piece of legislation on admitting privileges. I mean, every time you see a bill go up before the Supreme Court dealing with abortion, it gives the Supreme Court the opportunity, if they so choose, to make a decision on Roe versus Wade. What we've seen in the past, and I'm thinking Ms. Borley will speak more directly to it, is that the Supreme Court has been ruling on issues and the parameters of the Roe versus Wade decision. But the Supreme Court, at any time when a bill regarding abortion is before them, could rule on it. But right now, the status of Roe versus Wade is, unfortunately, it still remains the law of the land.
All right. Well, I just put it out
Yes,
there.
and I think the ladies beside me would like a crack at that as well.
Representative Jenkins, I can address your question. I'm Liz Merle from the Attorney General's office, and I'm the lead counsel in all of the federal litigation right now over state laws protecting women's health and protecting life. The status right now at the Supreme Court is that there are 2 cases from Indiana that the Supreme Court is considering granting certiorari in to evaluate 3 separate restrictions. One is an 18-hour ultrasound law, which many states have, and it's very concerning that the federal courts under current Supreme Court jurisprudence have struck ultrasound laws, which we have here as well, on a 24-hour waiting period. Our 72-hour waiting period, which was extended in 2016 legislation by the legislature, is currently under attack, and I'm defending that law. There is an Indiana law that prevents selective abortions for people who have disabilities and Down syndrome and things like that, conditions that are genetic abnormalities. It prevents selective abortions on that basis, which we also passed in 2016. I'm also defending that law here in the federal courts. That is currently in a petition pending at the United States Supreme Court in Indiana. There is another law that is similar to a law we have on the burial and cremation of human remains that is being defended right now by Indiana, and that's one of the challenges that they have. Our case, Representative Jackson's law from, I think it was in 2014, which required admitting privileges, is we are expecting a cert petition. We actually had the federal district court decision reversed at the Fifth Circuit, and now June Medical, the clinic who operates in Shreveport, is challenging that at the United States Supreme Court, and their brief is due Thursday. So I think that you will also hear Representative Kraus has a bill that's coming before this committee on Thursday that is a very good bill, which I think will give you some concerns about how these clinics operate. And so I think that you will, this is a good amendment. It preserves the right of the legislature, the state legislature, to determine what laws will apply to abortion. I think you will see some movement at the Supreme Court. There are a lot of states that are passing laws. They are passing fetal heartbeat laws. They're passing a number of different types of laws. There's a lot of push on both sides of this debate to push cases up to the Supreme Court. So we don't really know what will happen. We know that we can protect and we can explain what we think our state constitution says, and that it preserves the right for the legislature to legislate on this topic, and that our state constitution won't be misconstrued. So that's what this amendment does. It still preserves the right of the legislature to legislate if the Supreme Court actually gives you back that right under federal law, which is what we may or may not see happen in the next few years.
And besides Representative Kraus' bill, and I'm glad you brought up the legislation to let you know how important it is that right now Representative Kraus has legislation, Senator Mizell has legislation. For example, in Bossier City, an abortion clinic closed because we weren't so keen on the legislation when it closed. I think it was last year or this year. There was a question of whether or not they were providing abortions to young girls who were being trafficked from Fort Worth, Texas. They burnt all of their records. So now no one can pursue that investigation. Although there was kind of weighty information given to us that they may have been providing abortions for young girls who were being trafficked across state lines. And so at some point, we need to put some teeth in our Constitution so that when laws pass, like Representative Mizell's and Representative Kraus and others who are bringing bills this session, they can attack those laws. Because there's a lot of important stuff going on that are surrounding abortion clinics that we do not have access to, especially when you hear something that egregious, and by the time you have an opportunity to investigate it, every record has been destroyed. And so as these bills come forward to correct those issues, we want to make sure that our Louisiana Constitution oppose those bills so that when they're attacked in court, those pieces of legislation that I think are all, whether you're pro-life or pro-choice at that point, if we've been providing, if a clinic has been providing abortions to some young girl who's being trafficked across our state lines, we want to know that. And we want to protect those laws.
I have the highest respect for you. You know that.
Yes.
Right? And I hear what you're saying. And I think anybody out there doing something they shouldn't be doing, they shouldn't be doing it. That's really not the issue today. The point that I'm making is, and I know everybody's got a strong feelings about this. Whatever side you're on, you got strong feelings about it. The point I'm making is, I'm very concerned when we say someone has to go forward with a pregnancy when they've been raped or they've been the victim of incest, or if a doctor is sitting there saying, if you go through with this birth, this mother's going to die. Let me finish. Let me finish. And I'm gonna let you. I'm gonna let you say what you got to say, because I'm not trying to stop anything from moving forward today. I know how to count. Okay. The point I'm simply making is, I hope you all will give some thought to the exceptions. I think that's pretty important stuff that needs to be a part of this discussion. That's why I'm bringing it up. The only thing that jumped out of the bill to me was the fact that there was nothing there that provided for that. You talk about interpretations. That's not for the legislature to do. That is for the courts to do. We don't interpret constitutions. The courts, that's their duty. They interpret constitutions and what they stand for. If this bill was sitting here now saying, there's none in our Constitution has a right for you to get treatment for cancer or for sickle cell anemia or whatever the case may be. You understand what I'm trying to say? Those interpretations ought to be left to the courts. Having said that now, the only thing that I'm saying on this committee as a member of this committee today is, I hope you all will give some thoughts to the impact of the exceptions and not just have a blanket, a law out there with no exception to it at all. So that's my point. Okay?
And I understand your concerns. I think I know what our lead counsel has said is this: right now, Louisiana law does not recognize exceptions. The federal law does. But at any point that Roe versus Wade is overturned, or any of the federal law regarding it is overturned, then the Louisiana legislature will have an opportunity, or anyone in the legislature, to bring a bill, even if this passes, to determine whether or not there are exceptions. But right now, nowhere in Louisiana law is there exceptions, because it's recognized in federal law. And the right to abortion is recognized in federal law. And so if Roe versus Wade is ever overturned, what lead counsel has said is that this legislature will then determine whether or not to pass statutes or anything that would recognize exceptions, which we never have before because it's always been a part of federal law. But the legislature still would have an opportunity, is the way I'm understanding. You would still have an opportunity, if this passes, as a member of the legislature or any member of the legislature, to pass statutes regarding exceptions if the federal law is ever overturned.
And as a civil law state, right, legislative law, is primary law. This is where these issues should be decided. Does that make it easy for you guys? No. Would it be easier for courts to act like legislatures, like Roe versus Wade has done? Sure. But that's not what our federalist structure of government is set up to do. So this just puts the issue back into the people's hands. You all represent the people. You know what your constituents want, and we'll be able to handle that, with people that come to the table who are perhaps conceived in rape, or women who were traumatized by the abortion just as much they were traumatized by the rape. And so those type of things deserve a hearing in the legislative committee, and you'll be able to decide those questions.
You finished, Representative Jenkins?
Thank you, Mr. Chair.
Sure. And to be clear, always try to clarify when I can. Someone could bring that bill now, the exceptions bill now.
Yes. There's nothing restricting anyone from bringing the exceptions bill now.
Okay, very good. And Ms. Murrell, thank you for coming today to clarify some of the issues. I don't have a card for you. Did you fill one? Okay, very good.
Thank you. I know she's running to the Senate. The Attorney General has legislation in the Senate today.
Well, we always appreciate it when you grace us with your presence and your knowledge.
Happy to be here, and I'll be back on Thursday.
Excellent. Thank you. All right. Next up, we have President would like to speak. Christy Kraus from Family Forum. Ms. Kraus would come to the table.
Did they vote? No.
Oh, we're still on the amendment, aren't we?
We haven't adopted.
Oh, I apologize for that. So we have amendment set in front of us, 1123, which Representative Seabee has offered up on behalf of Representative Jackson. We've had a lot of questions. Do we have any objections to the adoption of that amendment? Seeing no objections, that amendment. Oh, did you have a question? Another question on the amendment?
So which one are we doing? The first one that
It's
we got?
amendment set 1123. The top right corner.
Oh, 1123. Okay, okay. But isn't this the one that Representative Seabee had a question with that we were going to fix? No. Excuse me?
He had a question, but he offered it as it's written with the assurance from Representative Jackson that if any members of this committee had a problem with it between here and the floor, she will definitely work with you.
Okay, so I didn't know if we was to vote on it today as it stands. So thank you for clarification.
Because Representative Seabee offered the amendment, we're going to go ahead and vote on the whether we adopt the amendment onto the bill.
Okay. And I know this is an issue, so if we want to, any member that wants to talk to me about this amendment, if it gets on, then please come see me. I don't care what your position is on the bill. I know part of the issue Representative Seabee had was a substantive issue, not his agreement with the bill. I've discussed this issue. We don't want it struck down, and so we'll be working with the staff because the staff did have an issue on some of the language as well.
Okay. Representative Dubas on?
I know it's in good hands. I'm sorry. I just wanted a clarification. Thank you.
Excellent. Always best to be clear. All right, members, any objection to the adoption of amendments at 1123? Seeing none, amendments at 1123 is adopted. We're back on the bill now. And we've called up Ms. Kraus from Louisiana Family Forum, and welcome to the Committee on Civil Law and Procedure.
Hello. Thank you, Chairman, members. Our Louisiana Family Forum President, Jeanne Mills, regrets that he was not able to be here with you today, but his schedule has him out of the country, so he's on an airplane as we speak. In 1973, when the Supreme Court created a right to abortion, they took on the role of the legislature. And what this will do, and of course that was in the federal system, but what this will do in Louisiana is have a clear expression of the legislative will and of the will of the voters and the people of the principle in our Constitution. And it will prevent a court from creating such a right in the future should Roe v. Wade be returned to the states. As an LSU graduate, Jeanne's pro-life ethic led him to direct a crisis women's pregnancy center and then eventually come to work at LFF. He grieved that despite the understanding about when life begins, abortion remains legal and women are sold on the idea that abortion solves a problem, when nothing could be further than the truth. Too many women bear the scars of past abortions, not to mention the many thousands of unborn children who have lost their lives in our state. We look forward to the day when abortion is not only unthinkable, but unnecessary, when women in crisis know that there are real alternatives to cutting a life short. That's why I'm here testifying on Jeanne's behalf for House Bill 425. It's a simple affirmation of the Louisiana pro-life ethic, stating that nothing in the Louisiana Constitution will be construed to secure or protect a right to abortion or to require the funding of abortion. The policy in Louisiana is and has always been to protect human life. And on a personal note, I would like to say that my husband was the late Senator Mike Kraus, who passed away back in 2013. And he was the author of one of the strictest anti-abortion bills in the country that was passed and unfortunately vetoed by then Governor Romer back in 1990. And this is a debate that we've been having here in Louisiana for 30 years, and we have always come down on the side of protecting the unborn. And it's interesting to note that at the very end of his life, in the final weeks, he commented many times that during his long time in public service, his work in this area on this issue meant more, gave his life more meaning than anything that he ever did while he was in public service, other than just the things he was able to do to help people on a tangible level. And so I think that really encapsulates the importance and the weight and the gravity of this issue. We don't want a state court to be able to override the will of the legislature, and we want the principle to be in our Constitution. That way the policy is clear, the intent is clear, And if Roe versus Wade ever gets returned to the states or overturned and the decision returned to the states, then this will be in effect. And the legislature will be able to do its job, not the courts. Thank you.
Thank you for coming to testify and representing Mr. Mills so well today, Ms. Cross. We really appreciate it. Have several cards in favor. Go ahead and read those into the record. Read, Mrs. Cross. Present will provide information if requested. Charles Carpenter from Baton Rouge, Right to Life. Brian Gunther from Louisiana, Right to Life. Not wishing to speak in support, Charles Rossman, representing himself. Gideon Rossman, representing himself. Rob Tasman, Louisiana Conference of Catholic Bishops. Dr. Will Hall, Louisiana Baptist Office of Public Policy. Helen Carver, Louisiana Family Forum. Diane Stevens, no affiliation. Dale Hoffpower, Louisiana Family Forum. Mia Boardley, Louisiana Right to Life. We appreciate all the testimony in favor today. And we have a few people opposed. If we could.
Representative Garofalo, may
Yes,
I
Ms.
offer
Boardley.
this into the record? This is just the list of the 12 states that have discovered the right to abortion, and then the 5 states who have passed similar amendments saying that there's no right to abortion. So Louisiana would be number 6 on that list.
I think the members would like to see that.
Okay.
If we can get a copy, we could get some copies made for the record and for the members. Okay, if you guys
Thank
can
you.
make way for us, we'd appreciate it. First up, Stephanie Bangle from New Orleans Abortion Fund, wishing to speak, and looks like Laura Fine from Life Louisiana, or Lift Louisiana. You can correct me on that if I'm wrong. Also in opposition, I'll read the cards now. Julie Schwarm Harris, no affiliation, and Angela Adkins from Louisiana Now. Good morning. Thank you. Welcome to the Louisiana House of Representatives and the House Committee on Civil Law and Procedure. Are you Ms. Bangle?
I am, and thank you for pronouncing my name correctly.
I believe me, it wasn't by choice. I'm just reading, trying to read it off the card. Please proceed.
Excuse me. Thank you. So, my name is Stephanie Bangle. I am the Volunteer and Outreach Manager with the New Orleans Abortion Fund, a nonprofit organization serving women across Louisiana. The New Orleans Abortion Fund provides financial assistance to clients who cannot afford the full cost of abortion care in our state. We work statewide in partnership with local medical providers to offer compassionate and empowering assistance to women seeking abortions and distribute financial pledges as available to offset the cost of this medical care. We affirm people's rights to control their bodies and their destinies, and we work to ensure that all people have access to quality medical care regardless of their economic situation. I'm here today to testify against HB 425. This bill is unnecessary, harmful, and insulting to the women that it purports to protect. On the human level, bills like HB 425 insult the intelligence and autonomy of Louisianians who seek to terminate their pregnancy. Our clients at the New Orleans Abortion Fund are strong, thoughtful people who have made an informed choice to end their pregnancy. 70% of our clients already have children. They understand what it means to raise a child and to choose to grow their family in a manner that reflects their visions and their aspirations. A person's right to determine her own future and her bodily autonomy are inextricably linked. When a woman lacks the right or the ability to control her reproductive health, her future is at stake. Laws that restrict access to comprehensive health care, which includes abortion, are most damaging among our most marginalized communities, including low-income women, women of color, rural women, and women who have been abused or assaulted. HB 425, as Representative Jenkins pointed out, does not take into consideration the needs of these communities, nor does it make exceptions for cases of rape, incest, or the health of the pregnant women. It is not our place as citizens or as politicians representing our community to make decisions about an individual's health care and future, because ultimately abortion is a decision about a woman's future. Does she want to be a parent now or ever? Does she have the resources to provide for this pregnancy and eventually a family? Is she ready emotionally, psychologically, and financially to take on the responsibility of raising a child? These are major life decisions that a person must make for themselves and in consultation with their loved ones, physicians, and faith leaders, not politicians. The legislature has already taken many steps to make that decision more difficult and to make the option of abortion far less feasible than before. This legislature should be focused on improving the health and welfare of our community, not replicating old efforts to limit health care. People in Louisiana suffer when restrictions like these are passed. Women are suffering now, and so too are the children born into families that couldn't support them. We call on you who have been elected to represent your community to trust those very constituents that you serve. Trust Louisianians to make responsible and considerate decisions about their own bodies, and vote no on HB 425.
Thank you, Ms. Bangle. Ms. Vaughn?
Hi, and I apologize for my terrible handwriting.
I wouldn't say it's terrible. Could have read it a couple of different ways, but it's Ms. Fine, correct?
It is, that's correct.
Thank you. Thank you for coming today.
Yes, thank you for having me. So my name's Laura Fine, and I'm an attorney, which is part of the reason why my handwriting is so bad. I provide pro bono legal representation to minors who have to get court authorization in order to have abortions. I'm here today to express my concern about this proposed constitutional amendment. House Bill 425 would use the state constitution to lay the groundwork to take away the right to abortion in Louisiana, and it would target poor women by making sure there could never be any public funding of abortion. This bill is not only harmful, but it's also a waste of time and tax dollars. Louisiana laws already withhold public funding for abortion, but the current law does make exceptions for rape, incest, and the health of the mother being in danger, which, as we've talked about kind of extensively today, this amendment does not make those exceptions. So not only would it prevent women in those situations from accessing abortions, but it also prevent them from being able to access Medicaid funding, which is there for them today to fund those abortions. And it's particularly troubling for a woman whose life is in danger, who can't afford to have an abortion to save her life, and now wouldn't have access to Medicaid funds to do so. Louisiana Constitution has never been interpreted to protect the right to abortion. The due process rights protected by Louisiana Constitution have not been interpreted to be broader than due process rights granted by the federal Constitution. And there's no reason to believe that our Constitution would ever be interpreted to find a right to abortion separate and apart from what's guaranteed by the federal Constitution. Louisiana already has a law in the books that makes abortion illegal in Louisiana if Roe v. Wade is ever overturned. And it would also lay the groundwork to criminalize women who seek abortions or doctors who provide care. As you know, abortion is already exceedingly difficult to access in Louisiana since there are only 3 clinics and countless hurdles someone must face before getting an abortion. Not to mention there's a proposal this session to ban abortions before most women even know that they are pregnant. And this amendment is another example of the legislature trying to force its will on low-income women who will be unable to pay for abortions out of state and unable to access public funding if they're in a situation like rape, incest, or a medical emergency. A constitution is meant to be a document that looks at how we operate and function as a society, how we structure our democratic process, and that affirms the rights we hold dear. It is meant to protect rights, not to take them away. Thank you for your time today.
Thank you, and thank you for being concise. We appreciate that very much. Members, any questions? Okay, thank you, ladies, for testifying today. We appreciate it. And I've already read the cards in opposition, and Ms. Muriel was already at the table. Representative Jackson, is she in the room? You have a question for? Oh, I'm sorry, Ms. Dubas, you have a question?
Sorry, yes. Just for the ladies that were up here.
Ms. Fine and Ms. Bangle, would you mind?
I'm
sorry for the lateness of that.
I'm sorry. I just have a quick question. Is your organization, do they ever, instead of spending money on assisting women who can't afford it, the abortions, do you spend money on doing birth control, providing them with that? I'm not trying to be funny.
That's a very reasonable question. Thank you for asking. I assume that was directed at me, the New Orleans Abortion Fund?
Yes.
That is not our lane. We work in partnership with other organizations around the state who support women's health care and health access in a variety of different ways, including organizations that provide access to birth control, sex education, things like that. We, as an organization, are really focused in on making sure that people have access to funding for abortion when that's what they're seeking.
Thank you.
Thanks.
Okay, Representative Dubas.
I said.
Thank you. Okay, didn't hear you. I'm sorry. All right, members, as part of our, while we're waiting for Representative Jackson to come back in the room, if we can ask her to come back in, part of our duty on the Civil Law Committee is to review every constitutional amendment independent of whether it comes to us, and this is under Rule 6.8A of the rules, the House rules, and that requires us to look at whether or not this matter requires an accomplished, can it be accomplished statutorily, does it require a constitutional amendment? Number two, does the ballot language accurately reflect the matter such that the voter knows what they're voting on? And number three, it looks at the ballot dates to make sure that we're receiving as much voter interest as possible. And staff has determined that the measure cannot be accomplished statutorily. And we're still going back and forth on the ballot language, but I think we'll work that up before the floor. And we already have an amendment to change the ballot date. So staff recommended reporting with amendments under Rule 6.8A. So based on this report and based on the fact that we've already amended the bill, I'm going to go ahead and offer up the Rule 6.8A report and ask if there's any objection to the adoption of that report. Seeing none, we'll go ahead and adopt the Rule 6.8A report. Back on the bill, Representative Jackson, would you like to close?
Members, just to say that
Representative Jenkins would like to make a statement.
I just want to be clear. I have no problem with citizens voting on issues like this. My concern is that what's going forward is going forward without the exceptions. I'm not going to object to anything coming out the committee today. That concern remains. I'm going to want some more clarification on the impact of the exceptions or the lack thereof. And I want to get some clarification also from staff between now and the floor on this issue. So I don't want a lack of some kind of objection from me here today to be taken without some context in the record. I have some concerns about the exception issue, and I'm going to look at it some more between now and the floor, and I've talked with the author about that also, to try to get some clarification. I'm going to talk with the staff about this language and how it may impact future exception legislation that may come into play, because those are the biggest and burning issues with me at this particular point in time. Mr. Chairman, thank you so much for allowing me to get that clarity in the record, because I know how these issues are. I know how passionate people are about these issues. I just want to be clear on where I stand right now. Okay,
absolutely, Representative Jenkins. It's an emotional issue for everyone concerned, and I certainly respect your viewpoints, and I'm glad that you were able to present them. And knowing Representative Jackson as I do, I'm sure that she will work with you. And please confirm with Representative Jenkins that you will between now and the floor.
And I've been up front. I'm going to get everyone the correct answers. I'm going to say that, I can't say that the bill is going to comport with exceptions if the staff has an issue, but you're going to have your correct answers. You're going to know how to vote on the bill. You're going to know whether you want to try an amendment on the floor, like I've done on bills that I didn't agree with, because I might not be with you on those exceptions, but I'm going to give you every opportunity. I'm going to work with you from now to the floor. I plan on hearing this bill next Tuesday if the speaker acquiesces, because that's Pro-Life Day at the Capitol. That gives us from today, that gives us a week to work on it. And even if we don't come to an agreement, and the members know this, listen, I amend members' bills or attempt to, and so it may be an opportunity that, you will go to the floor and it's not going to offend me. Everyone has a right to participate in the legislative process and bring out the best amendment. So I'll work from now to the floor with Representative Jenkins. Of course, I work with him all the time. It's going to be a pleasure. We serve on the Health and we co-chair the Health and Welfare Committee for the Black Caucus. So that'll be a pleasure. And our new rep, of course, I'm sure that you'll be working with Representative Jenkins to get the answer to that exception question as well. Representative Seabee and I and anyone else who wants to participate will be working with the staff on the language to make sure that we don't go into any gray area on this important amendment. Robert has already given us his staff opinion on it, Mr. Singletary, right? And so we will, and Drew, I think. And so we know we need to work with staff is what I'm saying on language. And we will do that. I stand ready to work with everyone.
You have any closing?
I think that was it.
That was it? Excellent. Okay. Anything else, Mr. Clapper? Ms. Boardley. Okay, we appreciate that. And just let me state for the record that I'm a little disappointed because it's a double-edged sword for me, because my daughter will be delivering my first grandchild on Tuesday, so I won't be able to vote yes on this bill, but I want to state for the record that as it is in its current posture, I would be voting yes. So
congratulations.
Thank you very much. We're very excited about it, but it's kind of double-edged, like I said, because I won't be able to vote on this bill.
Well, maybe she'll deliver in the morning, and you'll be here in the afternoon.
That's possible, but we'll get into all the details later. But I'm not anticipating being here on Tuesday. We appreciate that. All right, members, we have. Do we have what's the will of the committee? Representative Cruz has moved favorable to report
as amended.
As amended.
Remember, they get on us about that, Mr. Chairman.
HB 425 is amended, and along with the Rule 6.8A report favorably. Any objections to the reporting of this favorably? Seeing none, HB 425 will be reported favorably, and that's a unanimous vote from the committee. We appreciate all of the testimony
with preferences from Representative Jenkins and Representative
Dubas.
Dubas, right. With their preferences, I always like to put that on the record for members.
I'd like to thank everyone for testifying today. It's, as I said before, it's an emotional issue to a lot of people, and we really appreciate the passion that goes along with this issue, and you guys handled yourselves very well. Our next meeting will be next Monday, members. Really appreciate you guys coming today. If you have any issues between now and then, please get with me. And Representative Cruz moves that we adjourn. Any objections? Seeing none, we will stand.